Good morning, Mr. Beeler.
Good morning, Your Honor. May it please the Court, my name is Jeffrey Beeler. I have the privilege of representing Officer Dean Leavitt of the Whitman Police Department in this appeal. Unless the Court has an objection, I was going to dispense with the facts and start out by talking about what this case is not.
I had a question for you. The cases that you cite, and you cite a great number of cases from out of state, it seems to me that they all involve somehow the patient himself or herself is involved in injuring the other party, the person who ultimately becomes the plaintiff. Now, are you aware of any cases in which a third party is injured, not by the plaintiff, that the plaintiff is not injured by anyone in the doctor's care, but by somebody else, so that there's no direct contact between the patient and the plaintiff?
I am not, Your Honor.
So you're asking us to extend the law beyond where anybody else has. So all the cases so I don't see the relevance really of all the cases you cite.
Well, I would suggest that the relevance of all the cases that I cite fall within that area of the tort law that suggests that the foreseeability at issue doesn't need to foresee the precise sequence of events that occurs. This gentleman who left this hospital after...
Haven't we already ruled that way in Coombs versus Florio?
I think the Court has already ruled that way in Coombs versus Florio.
So now you're trying to push the envelope a little further.
I think this case is actually easier for this Court to decide than Coombs versus Florio, and one of the things I want to point out is that this case, excuse me, is contrary to what some of the amici are suggesting, is not an opportunity or a reason for this Court to reconsider Coombs versus Florio. Unlike Coombs versus Florio, the doctors in this case are not defendants. And the reason they're not defendants is there's no indication that they did anything wrong here. They did the procedure, they did it right, they gave correct orders, they told the staff at the hospital to release this man to a responsible escort. That's where the breakdown occurred.
Mr. Beeler, could I ask you a factual question?
Sure.
The patient has a colonoscopy, is given drugs that suggest that he should have an escort, and that's the hospital's policy. And then he walks from the hospital, and then he is struck by a motor vehicle. Correct?
That's correct, Your Honor.
And then the officer responds to a request for help. Is there anything in the record that tells me what happened at the first accident? In other words, is there anything that tells me that it was the fault of the patient as opposed to a drunk driver?
Your Honor, one of my problems in this case...
What's the answer?
Well, I think the answer is no, other than the inferences that can be drawn from what we have pled. And because
how can you draw inferences?
Well, we can draw inferences because we know from our pre-filing investigation and from what we were able to find out without the benefit of discovery, because I got no discovery in this case, what happened. And we also know from talking to the family of the gentleman who was killed and from their counsel, and there's a separate case, that what happened to this man was that he walked out while under the influence of these particular drugs. My problem in this case in many ways...
And then what happened?
And he was in the road where he shouldn't have been, Your Honor.
Is that before us?
That's what essentially I would suggest is the light most favorable to the plaintiff.
Do we have it before us that he was in the road? I mean, are you saying that he was in the middle of the road where he shouldn't have been?
This man was walking down the middle of a highway.
Okay, is that
I would suggest that flows from my complaint, and certainly we are here on a motion to dismiss standard, where I would suggest that under the circumstances the plaintiff should be given the benefit of all reasonable inferences. And that, I would suggest, are the facts of this case.
That's speculation. I mean, you know, you're suggesting some facts that aren't there, but I don't think it is necessarily a reasonable inference from a statement that an accident occurred that we should know the accident was, in a sense, caused by his condition related to the drugs.
Your Honor, this was an 80-plus-year-old man who had been given these powerful sedatives and went out of the hospital and was walking in a road where he shouldn't have been at the time he was struck.
But that's not in the complaint.
Don't know that. And maybe he had a heart attack and fell down. Like, he's 80 years old. Maybe he had a heart attack and fell down and got run over.
Your Honor, one of the problems I've had in this case from the beginning is I've had zero discovery in this case. All we could plead is what we knew based on our pre-filing investigation. We did that. All of the cases cited, and I believe both of the briefs, usually are at this point at the summary judgment stage where we have had the opportunity to do some discovery. I was able to do zero.
I understand that, and I think that reaching the second question, to which Justice Cowen's questions went about, are we extending any of the doctrines? But it seems to me that at least ab initio, that there has to be some basis on which we can say that the original triggering event, he may have been walking down the middle of the road. We don't know whether it was safe to walk down the middle of the road, and he could have been hit by a drunk driver. In other words, it's not the fact that he was walking down the middle of the road. Was there an accident report?
Your Honor, the evidence that we have...
Was there an accident report?
The evidence that we have from our pre-filing investigation in this case was that the driver who struck this man was not found at fault. So this guy is where he's...
Did you plead that?
No, Your Honor.
You didn't plead that?
No, Your Honor.
We've extended a duty to third persons in Coombs, and I know Coombs is different, but it seems to me that Coombs, and there are a number of other cases that are cited that talk about duties to third persons in this context, and it always has something to do with the operation of a dangerous piece of machinery and why that is particularly important in analyzing the duty and the foreseeability of injury and accident. Someone operating a car after taking prescription medicine, after having some other form of medication. That's not this case.
That's correct, Your Honor.
So, what makes you think we should extend the duty to third persons when there are no dangerous instrumentalities involved? Because that's a pretty big step.
Well, Your Honor, I'd suggest that the hospital's own policies recognized, and the reason that they were there was because they recognized that there were travel-related risks associated with releasing somebody who had been anesthetized in this fashion. And if this were an urban hospital...
There could be travel-related risks, and they may have... I don't know the circumstances, but, for example, they may have determined that... They may have made a determination that he was able to walk and could walk quite comfortably, and he wasn't going to drive a car. I don't know that. In which case, they may be liable to him if, in fact, it's proven that, as a consequence of that, he was hit by a driver who was complying in all respects, or he fell into a ditch or something. That's not this case. In other words, it's not the case where he got into a car and then slammed into somebody.
No, Your Honor, it's not. But these particular medications make it a travel risk for this gentleman to get home however he gets home. The requirement of having an escort is there whether you drive, whether you take the T, whether you walk. These drugs are designed to take away your ability to make rational choices and protect yourself. That is correct, and it is also the case that, obviously, if you're driving a car, the hospital, I take it, is going to look more carefully than if you're walking. So there may well be causes of action from the patient against the hospital, including the nurses. Mm-hmm. We would suggest that the risk of this type of accident happen, just a travel-related accident, was foreseeable to the hospital, and that's why these very policies were there. That's why these doctors entered the orders that they did. This is business as usual at these hospitals. Where the breakdown occurred was with the ministerial action of making sure that this man was with his escort so that this particular accident didn't happen.
Coombs is a case that deals with a duty to warn. But you're not talking about duty to warn. Are you suggesting that the hospital, if Mr. Augusto had said, yeah, I hear you, I need an escort, but you know what, I'm just leaving. I don't care what you say. What was the hospital to do then?
First of all, Your Honor, there's no evidence in the record that that's what happened here.
There's no evidence what happened?
Well, I think the evidence from the complaint, at least as pled, is that he was discharged without getting the escort.
But you haven't pled that the driver was not at fault. I'm not sure that would get you over the hump, but at least you haven't indicated in any respect that there's any connection between what you allege is a failure to carry out a ministerial duty and the car accident that involved the patient?
Your Honor, based on the information that we had at the time we filed this complaint, I would suggest that given the standard that was then in place under, in connection with motions to dismiss, that we pled a sufficient causal nexus between the impact of these drugs on this man and what happened, that if all the reasonable and fair inferences were taken in our favor, we did and should have gotten over that hump. And in the usual course of this case.
But let me ask you, under your theory, a police officer responding to an accident caused by person A's negligence, whoever it is, a police officer responding to an accident caused by somebody else's negligence, who himself is injured by driver B, a totally independent accident, the police officer would always be able to file a claim against the negligent driver A in the first accident.
Your Honor, I would suggest that that's what the rescue doctrine, which is recognized in Massachusetts, stands for. I would suggest that under the appeals court case of Hopkins versus Medeiros, which relied on cases from this court, that's what the law is in Massachusetts. I would suggest that commentators in tort law...
Which cases, I know the rescue doctrine, but which are the factual circumstances where you think this court would recognize, the closest to recognize?
I think the closest case that I've been able to find from an appellate court in Massachusetts is the Hopkins case, Your Honor, which is why it's featured prominently in my brief. I would also suggest that the rescue doctrine has been recognized since the 1920s by Chief Judge Cardozo. I would suggest that Prosser...
Yeah, but nobody's doubting that we recognize the rescue doctrine, correct?
Well, my suggestion is that in response to Justice Spina's question, I would suggest that, yes, that's a possibility. And I'd also suggest that the statutory mechanism set up by the legislature relative to getting reimbursement for essentially the workers' compensation payments that were made to officers like Officer Leavitt.
Let me just go back to the Hopkins case. The Hopkins case touches on the rescue doctrine, but there what you have is, unlike Justice Spina's hypothetical, you have the defendant who's sued by the police officer was the one who had caused the melee that resulted in the police being called and resulted in the police officer being injured, correct? So there's a direct relationship between, if you're going to cause a melee and the police officer responds and is injured, under the Hopkins ruling, you have a cause of action, or at least you can get past a motion to dismiss. But here you're at least two removed from that, because you've got the factual equivalent in your set of circumstances is that the police officer would have a cause of action against the driver of the car who acted negligently and injured him.
That's correct, Your Honor. And what I would suggest that in this case, our theory is that the failures by the defendants were essentially the events that caused the melee in our case. They discharged this man in a condition where harm was foreseeable. And under our system that society is designed, rescuers will come running. That's the way this is designed to happen. And the hospital takes the position that that part of this is unforeseeable when it itself is part of that system. Ironically, both the man who was struck and killed and Officer Leavitt were brought back to that hospital by other emergency responders to the very same hospital.
So what would happen in the course of a trial here? If would a defense of supervening negligence be an issue?
Oh, absolutely, Your Honor. I think that they will argue that the conduct of the vehicle which struck Officer Leavitt was a superseding cause. But that is a very fact-intensive analysis. And I have been denied of the opportunity to get at those facts.
Was there a finding of fault of the driver in that case?
I'm sorry, Your Honor?
Was there a finding of fault on the part of the driver who injured your client?
I don't believe so, Your Honor.
There was no in the accident report?
Your Honor.
It's your client. He's in the accident.
Oh, in that case, Your Honor, I believe there was. And there was a case brought on his behalf.
So we know that the driver was at fault.
Correct. But as this court has said on a number of times, on the issue of superseding cause, it's not resolved by the number of intervening events or agents, but in their character and in the natural and probable connection between the wrong done and the injurious consequence. Only unusual, extraordinary negligence of a third party will excuse an original tortfeasor's liability. I don't think you can reasonably argue that an automobile accident occurring to anyone, let alone an officer responding under the exigent circumstances of an emergency response, is unforeseeable. It's going to happen. The legislature has passed statutes because it recognizes that this is going to happen.
Thank you, Mr. Beeler. Your time is up.
Thank you, Your Honor.
Good morning, Mr. Buonaconti.
Good morning, Your Honor. Daniel Bonaconti from Foster and Eldridge here on behalf of all of the defendants in this action. I'd like to begin by pointing out, as was by this court at the very outset of argument, that what the plaintiff is seeking in this action is an expansion of liability far greater than that recognized by any court in this Commonwealth and far greater than that recognized by any court across the country. There has been an abundance of case law cited in the briefs on behalf of the appellants seeking this court's favor. However, none of the cases are applicable. All of the cases actually involve harm resulting from contact with the patient.
But all right, I see that, but then how does the rescue doctrine come into play here? Let's assume for a moment that the patient here left the hospital, didn't proceed to walk home, but actually got in a vehicle and drove home and caused the accident, the first accident. Same fact scenario, police officer coming to the scene, responding to an emergency, is hit by another negligent driver. Doesn't the rescue doctrine cover that officer? Couldn't that officer sue the patient, for example?
Well, respectfully, Your Honor, as it pertains to the rescue doctrine, I say the rescue doctrine is not applicable because Officer Leavitt, in this fact pattern, does not qualify as a rescuer.
Because it wasn't voluntary?
No, that is not the reason. The Hopkins-Medeiros case lays out certain criteria.
I know. Was this a voluntary rescue?
It was a voluntary rescue, but being voluntary or arriving at a scene by virtue of your employment does not disqualify you as a rescuer in and of itself. The reasons Officer Leavitt is disqualified or doesn't qualify as a rescuer is first, he wasn't at the scene. The criteria established by Hopkins-Medeiros is that the person must actually be at the scene. The person must have a specific mission that he has undertaken to ameliorate the peril befallen by the victim. He has to actually be in the act of rescuing the person. The court goes on to state that mere investigatory actions do not qualify him as a rescuer. In our fact pattern, Officer Leavitt can't even be said to have been investigating because he wasn't there.
But if he gets a dispatch saying there's been a terrible accident, get there as quick as you can, call emergency medical system, this person's on their, it's reported is on their last legs, use CPR, do what you can do. And so he gets into his cruiser and he drives very quickly. Does the fact that he wasn't there when the accident happened would disqualify him from the rescue doctrine?
I want to be clear on your question, Your Honor. The fact that he wasn't there when the injury to himself happened disqualifies him as a rescuer.
I thought you, I'm sorry.
No, he doesn't have to witness the accident to the patient.
That's what I thought you meant.
No, it's what Hopkins, in fact, spells out quite clearly.
So he would have to have arrived at the scene, and while attending to whoever was at the scene and had been injured, perhaps the plaintiff officer was struck by another car.
Struck by another car, perhaps even so simple as injuring his back trying to lift the patient. Something specifically attempting to rescue this person to ameliorate the peril, more than investigatory.
Would you agree with me, maybe you wouldn't, that if in fact the patient had got into a car and the hospital was aware that the patient was going to drive himself home, that the hospital might in fact have, or the employees of the hospital might have a duty to third parties who might be injured by the patient? Would you go that far?
Well, Your Honor, fundamentally, that analysis, that inquiry kind of takes us back to the ruling in the Coombs case. And while, to be honest, I agree with your dissent in the Coombs case more than the actual holding of the Coombs case as a defense lawyer in general, if you take that hypothetical, okay, and let's add an element to your hypothetical that they warned him or they failed to warn him not to get into that car.
Well, then you're changing the facts. Coombs is warning.
Right.
This is sort of treatment of a kind. Although I think it probably comes closer to Mr. Beeler's characterization of it. It's an administrative policy, right?
Well, along those lines, that administrative policy creates a duty to the patient.
No,
Okay.
I understand that, but what I'm saying is that there's nothing special about this administrative policy or about any other administrative policy. That is to say, this happened to be in the wake of a colonoscopy and being given, drugs that place patients at risk. But there are lots of circumstances in which people are released from hospitals, which may be in violation of policies or not. I mean, Coombs seems to me to be a completely different entity here.
I agree. I was attempting to rationalize for purposes of the answer. I don't believe a duty exists under this fact pattern to third parties. But if it did, it wouldn't extend so far as to include Officer Leavitt, who has no nexus to the injury to the patient.
I suppose that in an inartful way, what I'm asking you is the following. In the Coombs case, there are states that have held that a failure, and as did Coombs, that a failure to warn can give rise to liability. I don't know if there are cases that say that the failure to adhere to an administrative policy gives rise to third-party negligence.
I'm not aware of any such cases, Your Honor.
Well, is that really all that's going on here? Again, assume there's a lot of outpatient treatment these days. A lot of that treatment involves the use of various drugs for outpatient surgical things. Colonoscopy is a perfect example, but there are others that will affect someone's judgment. Generally, the policy or the practice is not to let you, leave the hospital alone, and certainly to keep you for a period of time before they let you even be released to someone. So if the hospital has directly administered the drug that puts you in a position to injure yourself or someone else, isn't that even a stronger case than Coombs for duty?
Well, hospitals in and of themselves do not administer medications. Individual actors do, physicians do.
Okay.
Physicians are not defendants in this case. This case
Gotcha.
involves the hospital entity and nurses. So I don't think the analogy can be made there, Your Honor.
But the purpose of the policy, obviously, is to ensure that the patient is either got their full senses or is with someone who can ensure that they don't injure themselves or someone else. I mean, that's the policy, and the reason for the policy is that because you've been given drugs at the hospital that might have that effect.
I would agree that the policy inures to the benefit of the patient to whom the duty is owed. And that is the problem with this case, is that there is no duty owed to Officer Leavitt. He is not a reasonably foreseeable class of victim in this case.
But would I think this is where we started this question, but if the duty is owed to the patient, and the patient drives, or in some way there is a third person injured by the patient as a result of having left while still in a too medicated state, would you say, no, there is no duty owed to that third party? I know that's not this case, but would you say would that be a duty owed to that third party?
Your Honor, and this is at the risk of sounding very evasive, I don't think I can answer your question without a greater fact pattern.
Assuming that there's a warning, would you say that there's a duty to a third party?
Assuming a warning was or was not given, Your Honor.
Was.
Well, if I understand our current status of the law correctly, if the warning was given, then the medical provider has complied with the recent holding in Coombs, and therefore there is no liability to that third party.
But am I correct, putting it aside from the medical context, if this were a dram shop case, and somebody goes to a bar, gets drunk, drives, gets into an accident, police officer responds, gets into an accident on the way, would you still say there that there's no liability of the bar to the police officer because the rescue doctrine doesn't apply unless he's actually at the scene?
And just for clarification, the accident in your hypothetical that the police officer is involved in is wholly unrelated to the patron who imbibed too much alcohol. Is that
No,
correct?
he's responding to, just like here, he's responding to a
yeah,
report
but
of a
he- but
serious
the
accident.
answer- answer is yes.
It wasn't caused by the patron who had too much alcohol.
Right, right. He gets into a separate accident, police call goes out, serious accident on Main Street, police officer races to the scene, and on the way there, gets into an accident and is seriously injured. Something which I guess we could construe to be the allegation here in a different context. Same result in terms of the rescue doctrine not applying, or are you saying the rescue doctrine should be defined differently because this is a case involving a hospital?
Same result, Your Honor. I don't believe the rescue doctrine is applicable in that hypothetical, just as I don't believe it's applicable in our current.
Are you
In
saying because he wasn't at the scene, but he was on the way to the scene? Is that the distinguishing factor?
It's one of them, Your Honor. He wasn't at the scene. He hadn't undertaken an actual specific mission to ameliorate the peril of the victim, as outlined in Hopkins.
Well, how can you say that latter statement? He's on his way as fast as he can go. Maybe he's going to get there in time to save the man's life or the woman's life.
But he has to be in the mission to actually save the life.
So I'm saying, is your distinction therefore, well, he is in the mission, he's on the way to the scene, but unless you make the distinction that he's not at the scene.
That's what the cases
That's
have.
what I'm asking
That's what the
you.
cases have distinguished. Do we have to look to the legislatures dealing with the firefighter rule? I mean, in other words, in all of these, there's a very specific set of constraints in the rescue doctrine that applies to firefighters and police officers. No question that he's here acting as a police officer, correct?
He is acting as a police officer.
Do you agree with the result in Hopkins?
I do agree with the result in Hopkins as the applicability of the rescue doctrine as that officer complied with the criteria as laid out by that court. He was injured in connection with that scene. It was
But I take
reasonably
it that in that
foreseeable.
case, that there was the legislature talks of intentional and negligent tortfeasors, correct?
They do in terms of the melee and the actions of the defendant, I think, in throwing a can or some object at the police officer.
Right, which is what happened in Hopkins,
Correct.
correct? If it-
I just want to, back to my question about if he had been injured by this patient, if not responding, just the patient is driving and a pedestrian, you would say you'd need more facts to know whether the hospital would owe a duty to that person injured if the patient were driving and still medicated, had left the hospital because nobody made him get an escort?
If we're not talking about a duty to warn case, then I would need more facts, Your Honor.
Okay, so, but I mean, this isn't a duty to warn case, right?
Agreed.
And that's what you would, I mean, that's one of the reasons I take it you would say Coombs has no application here.
It is one of the reasons, Your Honor.
How do you interpret the restatement? I always have difficulty, frankly, with their language. How do you interpret the restatement's position on this subject?
Well, Your Honor, the restatement's position, first let me premise by saying, if you have difficulty with it, someone like myself is surely to have difficulty, but it all falls to the premise, ultimately, of a reasonably foreseeable class of victims. The defendants in this case have no connection whatsoever with Officer Leavitt. They have no duty to Officer Leavitt. They have no control over the actual harm that befell Officer Leavitt, and that being the actions of the other driver who struck his car by not complying with statutory guidelines and frameworks of, pulling to the side of the road. They can't control that. They have no connection with that other driver, Mr. Tripp. Likewise, Officer Leavitt can't assert any reliance or expectation that the defendants in this case would have somehow prevented that driver from striking his car. That doesn't exist in this case. There's no relationship between the defendants and the plaintiff in this case, and quite frankly, no special relationship can be created because there can be no control by the defendants over the instrument that actually caused the harm, which is the other driver.
Thank you, Mr. Buonacorsi.
Thank you, Your Honor.